morning, everybody. I'm Jesse Weber, and welcome back to Law and Crime. This is where we cover some of the most interesting live trials in the country today. And we're so happy that you're joining us because we have a very, very exciting day for you. So let's go right into what's happening today. Okay, for anybody who's been following us, you know that we are still, that's right, still in verdict watch in the Tex McIver case out of Atlanta, Georgia. This prominent attorney who's on trial for shooting and killing his wife, Diane MacGyver. Now, the defense team and he are saying it was all a tragic accident. The jury has been deliberating since last week. I want to make sure I get this number correctly. They've been deliberating now for approximately 21 and a half hours. We believe they will continue their deliberations today, and maybe we'll get a verdict. Now, remember, Mr. MacGyver is not only charged with different crimes, including murder and aggravated assault, he also faces that one count of influencing a witness. That's right. He is charged with trying to influence or tamper the testimony of Danny Jo Carter, who is the woman that drove the car in question on the night Diane MacGyver was shot and killed. She was the main witness in this case. So there's a lot at stake here for Mr. MacGyver, on top of the fact that we've been covering the fact that he could be charged with he could be found guilty of murder, or he could be found guilty of involuntary manslaughter, which is a lesser crime, or he might be found not guilty across the board. We don't know what the jury is doing. We do not know, but we know that they are carefully deliberating this. And according to their reports early on Friday, they said they are making progress in the deliberations. So I am keeping a very careful eye right now. I'm seeing the courtroom feed. If I should see anything, don't worry. I'm going to go right into that courtroom. We will not miss anything. We want to bring that verdict straight to you. And hopefully, fingers crossed, we don't have a mistrial or hung jury or anything like that. But again, we'll focus on that case in a minute. I want to now talk about our main trial of the day. This is a case that we talked about last week. It's the case out of Ohio, and it is the case of Shawn Grate. He's an accused serial killer who's now on trial for 23 counts in this indictment, including the deaths of 2 victims, as well as the kidnapping and rape of a 3rd victim. We have a short preview of this case. We believe the trial will last anywhere from 4 to 6 weeks, and we do have an update in this case. So I want to show you a short preview of it, and then I'll tell you the latest development in the Shawn Grate case. Take a look.
The trial of a suspected serial killer, 41-year-old Shawn Grate, is set to begin Monday in Ashland, Ohio. Grate is accused of kidnapping and sexually assaulting a woman who prosecutors are calling Jane Doe in September 2016. Doe was allegedly kidnapped and raped many times by Grate in an abandoned house near downtown Ashland, but was able to escape after calling 911 while he laid asleep.
What's the problem? I've been abducted. Who abducted you? Shawn Grate. Where's he at now? Asleep.
After nearly 20 minutes on the phone with 911, Doe was rescued by police and Grate was arrested. Following Grate's arrest, investigators searched the abandoned home and made a stunning discovery: the bodies of 2 women. The women were identified as Elizabeth Griffith and Stacy Stanley. A preliminary autopsy showed both women were strangled, and Grate was charged in connection with the murders. Grate faces 23 counts, including aggravated murder and kidnapping. If convicted, he could face the death penalty. For Law and Crime, I'm Rachel Stockman.
This is a case to follow. Again, it's out of Ohio. This man faces a 23-count indictment, and we learned something very interesting on Friday. We learned that the trial will be bifurcated. That's right. It's going to be split up, and I want to explain it to you right now. At a hearing on Friday, the judge said that the jury will first hear arguments to determine whether Grate is guilty of the offenses that he's charged with and the sexual motivation specifications. Now, if he is found guilty on that, then the trial moves into the second phase. The jury will be asked to consider the sexually violent predator specifications in this second trial. If they find him guilty now on both of these trials, then it'll be off for a few weeks, and then the jury will have to decide what should he be sentenced to. So if you're sitting on this jury, and again, what we know right now is we believe opening statements will begin today. The jury will be finalized today. They're still picking some last-minute jurors, and we do expect openings before lunch. So if you're sitting on this jury, you're going to be here for a long time. Again, we anticipate 4 to 6 weeks, could be longer, could be shorter, we'll have to see. But this is an interesting case and a really disturbing case where you have two victims. Mr. Grate himself, if you've read anything about this case, he's had a lot of run-ins with the law. He's been in and out of trouble. He is suspected of killing other people that are not even connected to this case. In fact, the police and investigators are trying to find and identify somebody that he said he killed, and they're doing a special technique to try to identify what this woman looked like. Bottom line, Mr. Grate has been accused of being a violent sexual predator as well as a serial killer. So you're not going to want to miss this case. Again, as soon as we have a feed, we'll make sure to go to it. But I want us to take a step back before we do that. One of the interesting things, and we played a little bit for you in that package, was this Jane Doe. Obviously, we can't release her name. This is what investigators are calling her. Jane Doe called the police. She was the woman that was rescued and said that she was kidnapped and raped by Mr. Grate. I want to play for you right now her 911 phone call in its entirety. Listen, it's pretty chilling.
911, what is the address to your emergency? 4th Street, Laundromat. What's the problem? I've been abducted. Who abducted you? Shawn Grate. Where's she at now? Asleep. Where's she sleeping at? In the bedroom. Please hurry. Does he have a weapon? He's got a taser. Are you tied up now? Yeah, but I kind of freed myself. Are they on the way? Yeah, we have officers we're sending. Please send them up. Hey, if you're worried you don't have to talk, you can just set the phone down, okay? I just need to hear if the officers find you or not. Oh, shit, I woke him up. You just set the phone down. Okay, can you get to the door where you can see out? Huh? Can you get out of the house? Locked. It's locked. Are you at the door? Yeah, I am. She's at the door.
Come on out. Hurry up. Get out here. Where is it?
Bedroom sleeping.
Still sleeping?
Yeah. Okay, they have her. He went unarmed.
He's unarmed?
Yeah.
All right. Right now. Do it. Don't do it.
It's amazing when you can capture that. Really, you hear what happened when they rescued this woman and then when they took Grate down. So I should correct myself. It wasn't the entirety of that 911 phone call, but it really was some key moments of it. And you know that's going to be played in Mr. Grate's trial. It's not looking good for him when they play that. What I want to do now is just move back to the Tex McIver case. So as you know, we've been carefully monitoring that case. I'm watching the feed right now. We are on verdict watch. We're waiting for the jury to come back, and they may very well come back today with a verdict in this case that's really captured the nation's attention. We've been following it for weeks, and also it's been in the news for over 2 years, so we can't wait to finally have a conclusion. This is a short package explaining where we're at right now in the case, and it helps you frame the best arguments from both the prosecution and the defense. Take a look.
Jurors are deliberating whether Tex McIver is guilty of murder, aggravated assault, weapons possession, and influencing witnesses. MacGyver says he accidentally shot his CEO wife, Diane MacGyver, when a friend was driving them home from dinner after a day out at their ranch.
In this case, we know by way of the evidence that this is not an accident. This is not a malfunctioning gun that just went off.
The defense challenged that by reminding jurors of a huge piece of testimony.
Oops. He's demonstrating it for you on the witness stand. He accidentally pulls the trigger.
The state says the trajectory of the wound, just inches from the victim's heart, was deliberate. The defense says the state's theory relies on too many coincidences.
Diane tells the the, doctors and the nurses it was an accident. Is that part of the plot? Is that something that the state's going to claim, that Tex McIver had this thing so well planned and calculated, he convinced the last words that his wife said was, it was an accident? I mean, we're not talking about reasonable doubts here. We're talking about just astonishing improbabilities.
Friend Danny Jo Carter was driving the MacGyvers home the night of the shooting. The highway was clogged, so she took the surface roads through a neighborhood Tex McIver considered unsafe. He asked for his gun. His wife handed it to him.
If you're going to murder someone, why do you shoot her in front of her best friend? Why would you do that? Come up with one reason that says, I know what I'm going to do. I'm going to wait till Danny Jo Carter is, 8 inches away from me and 8 inches away from her best friend. That's when I'm going to commit the crime. I mean, try to sell that on, to Hollywood or a TV show, and they say that's a ridiculous plot. It makes no sense.
Prosecutors pointed to a financial motive.
In this case, we know that the defendant was under pretty extreme financial stress, that he was living up here and earning down here.
And y'all have seen hundreds of thousands of dollars flow into that estate account and flow out. They still haven't been paid. Why? He never intended to pay them. This ain't no Chef Tex, Southern gentleman. He's a guilty murderer.
The defense disagreed.
These are their witnesses that they want you to credit. Every one of them talked about how much in love they were. Every one of them testified that there was no arguing between them, there was no hostility between them, there was no animosity between them, and yet the jury wants you to, the prosecution wants you to just ignore all that and say, nevertheless, 10 o'clock, Sunday night, September 25th, I'm going to kill her, the woman I love.
The case has been filled with strange insinuations, like that the defendant was having an illicit relationship with a masseuse. On the stand, she denied it. Prosecutors tried to walk back that theory.
Never said they had sex. This is what I am saying. It just don't look right. I don't care how you cut it, Mr. Defendant. It just don't look right. And it is not consistent with the person that you have portrayed yourself to be.
Jurors have a lot to sort out in deciding MacIver's fate. This is Rachel Stockman for Law&Crime.
All right, ladies and gentlemen, that's where we are right now. The jury is deliberating in the Claude Tex McIver case, and we are waiting to see what happens. But what should we make of the fact that they've been deliberating for such a long time? Let's talk about it a little bit more with criminal defense attorney and former prosecutor Randy Zelin. Randy, good to see you.
Morning.
So they've been deliberating for, let me make sure I get this right, over 21 and a half hours, about 21 and a half hours. In your experience, what does that tell you right now?
It tells you nothing.
Nothing.
You learn over time. There is the old way of looking at things, which is the longer a jury is out, the better it is for the defense. But I have tried enough cases over my 30 years to know it means nothing. I've had juries out forever and come back and convict. We've seen high-profile cases where juries have been out for a week and they come back and they convict. We've seen quick verdicts, and I've been involved in quick verdicts where I get an acquittal, where you would think a quick verdict is a prosecution verdict. What this means simply is that you've got 12 jurors who I would think are very carefully and very thoughtfully considering the evidence, and right now they have not reached a unanimous verdict. Now, here's what we do know. We can reasonably say that they're not deadlocked, because they haven't sent a note out saying that they're deadlocked. They haven't sent a note out which sounds like, look, Judge, we just cannot reach a unanimous decision, where at that point a judge has a decision to make. Does the judge go back and nicely say, look, ladies and gentlemen, you've got an obligation here, and you promised me that you would do your job. I need you to go back and keep deliberating. Some judges then go to the next level, which is basically order the jury, go back, deliberate, and get to a verdict. And then only then, if the jury still cannot reach a unanimous verdict, will the judge then consider a mistrial.
So break it down for us, just for people who might be new to this, the idea that they said they're making progress. They said that on Friday. What is the difference between them being deadlocked and them still deliberating? Is it some jurors saying, look at my point of view, or you're not considering this, or maybe we need to look at this piece of evidence? They seem to be really working hard to come to a decision. What's the difference? What's that line between we can't come to a decision and we're still trying to figure it out?
It's just like that. We can't come to a decision, whether it's because somebody's throwing papers at somebody else or calling somebody else names, or a juror simply saying, listen, I don't care what you have to say. My mind is made up, and you're not changing it. So clearly, we have not gotten to that point. Now, a lot of times with juries, what it really comes down to is a juror understanding the definition of reasonable doubt. A less experienced judge will simply say to the jury, listen, it's your job to deliberate and reach a verdict beyond a reasonable doubt. What does that mean? It means a doubt based upon reason. That's not a definition. The definition of reasonable doubt simply is when you have to make a very important personal decision in your life. If, let's say, a doctor says you need to have open heart surgery. If you have enough information to say, doc, go ahead and schedule the surgery, you do not have a reasonable doubt. Conversely, if you look at your wife or your significant other and say, you know what, I need a second opinion, I need more information, then you have a reasonable doubt. So if the jurors really understand what reasonable doubt is, they're simply being very thoughtful and ensuring to themselves, because remember, you're passing judgment like God on somebody else's life. And if you're really not sure about it, then you should acquit. And if you're not going to be able to live with that decision once you come back, then you've got to acquit.
Now, we're not, I wish we could be flies on the wall, but we're not flies on the wall. Do you think that they are really struggling with whether this was murder or whether this was involuntary manslaughter? Or do you think maybe more of the struggle is whether this is involuntary manslaughter and this is an accident?
It sounds to me like the prosecution has really portrayed this as a murder,
yes,
as intentional, as motivated by money, motivated by greed, wanting to get the wife out of the way. And we've seen this time and time and time again. When the prosecution goes for the gold, they reach. Instead of looking at the case and saying, it may not be as sexy, it may not even get TV coverage, but let's go for what the evidence takes us to. And this may be an instance where the jury or the jurors or a juror or two jurors are struggling with this notion of this guy would intentionally kill his wife. And maybe the most compelling argument is, why would you do it in front of your or her best friend?
Right.
I mean,
there are
so many other ways, if you want to off your spouse, that you could do it, make it look like an accident, and there's nobody around. So it may be simply that. Here is a well-respected attorney who, again, if you're a juror, even if you're not supposed to do this, you're saying, guy's a lawyer. If anybody's going to know how to get away with murder, it ought to be a lawyer.
Randy, I hate to tell you this. Not all lawyers are smart. Not all lawyers are smart.
Anybody with the name Tex McIver, I mean, like right out of the TV show, this guy should be able to get himself out of a hostage situation.
Now, that's good.
With a pair of matches.
And the whole time I've heard this case, no one's made the MacGyver reference, so that's interesting. Okay, guys, here's what we're doing. So, again, we're carefully monitoring the Tex McIver case, but we are also carefully monitoring the Shawn Grate case. And Randy and I are going to talk about both, but what I want to do right now is play for you the testimony of Ross Gardner. He was the crime scene analyst brought forward by the defense, and he raised a lot of questions about how this shooting took place. Take a look. As we wait for the jury's verdict in this case, you have to imagine that this testimony is really something they're thinking about. And so let's break it down a little bit more. Again, I'm here with Randy Zelin. This guy, we're going to play more of his testimony, Ross Gardner, really hit upon the prosecution's theory that he said, look, the gun, it was impossible that it was held upright, that it was pressed against the seat. It had to be at least 6 inches back from the seat. It was held on his lap. It was turned sideways, all showing this looks more like an accident than an intentional shooting, because the question is, if you're going to intentionally shoot your wife, why place the gun in that position?
Again, the prosecution can't have it both ways. And you said something that resonates with me now a few moments ago, which is not all attorneys are that smart, which means you've got to pick if you're the prosecution, is this guy so brilliant that he actually planned this out to such a degree where he said to himself, you know what? I can't, when I do this, in order to make it look like an accident, I can't press the gun up to the seat, because if I do that, the physical evidence will be consistent with that. The hole will be different. There will be burn marks. There will be all kinds of things that an expert would be able to say, yes, this defendant put the gun up against the seat and fired the gun. He'd have to be that brilliant, but as you just said, okay, he's clearly not that brilliant. So then, which is it? And I think what you're seeing right now, if you do want to read a little bit of the tea leaves, that is exactly what the jurors are struggling with. It doesn't make any sense to them unless they believe he is the most diabolical guy in the world, has been planning this for 5 years, has even met with experts who could explain to them, this is exactly what you need to do to make it look like an accident. Have the gun on your lap, sideways, sitting on your lap, so this way you hit a bump or something happens, boom, the gun accidentally discharges, and man, it looks just like an accident.
Well, let me ask you this. If they were not trying to push so hard that this was planned in advance, but that this was an intentional murder in the moment, because under Georgia law, he could have formed that intent to kill her moments before he did it. Let's say they were painting a picture that they had a bad marriage, in the sense that they had a different kind of marriage. She was loaning him money, he felt dependent on her, she was teasing him, she had a sharp tongue. They're in the car together. She keeps teasing him. At that moment, he couldn't take it anymore, fired the weapon. Is it the prosecution pushing too hard for this planned murder that maybe that made more sense, that at that very moment going through his head, which we can't get into that mind, maybe it was an intentional shooting?
Here's the thing. If you look at wrongdoing on like a spectrum, so over here you have an acquittal. Over here, you have guilty, it was an intentional murder, he planned it, he plotted it, and he executed it. Now, what you want to do here, if you're a smart prosecutor, how far am I? How much am I asking the jury? What kind of a leap of faith am I asking them to take? Now, if you move it over to what you just said, which is it wasn't planned, maybe even more than a few moments prior thereto. It's still an intentional crime, so I still think you're pretty far apart.
Yeah.
Now, move it closer. What's the closest you can get to? Well, an accident could be criminal negligence. You could have a reckless act, which is you close your eyes to the high probability that someone could get hurt or get killed. You can also have something that happens in the moment, heat of passion. Right. So what I would respectfully submit to you, that as a prosecutor, I would forget about the intentional murder. If I want to convict this guy, I'm going to go for manslaughter. Whether it's the result of heat of passion, she was teasing him, he momentarily lost his mind and pulled out the gun. Maybe he didn't even mean to shoot her, but just pulled out the gun with just wanting to feel better that he had it in his hand, like to himself, saying, man, I could really off her, and the gun goes off accidentally. So whether it's heat of passion or whether it's criminal negligence or whether it is recklessness, it's not intentional, and it's, to me, a lot easier for the jurors to buy into this argument of, you know what, he really acted in a manner that no reasonable person would behave, and had he not taken the gun out, she'd still be alive.
Well, a common criticism has been that when he was initially charged, he was charged with involuntary manslaughter and reckless conduct, and it seemed like a slam-dunk case for the prosecution, and when they upped it to murder, that might have been not the best of the situation. But then again, we don't know. We don't know what's going to happen. We're carefully monitoring this. And Randy, stand by. What I want to do is play, again, this is some more of Ross Gardner's testimony. And when we come back, Randy and I are going to talk a little bit more about MacGyver, but we're also going to get into the Shawn Grate case that we're covering later today. Take a look some more at the testimony of Ross Gardner. All right, ladies and gentlemen, we're recapping the Tex McIver case as we are in verdict watch, carefully watching the courtroom feed. If anything should happen, we're going to make sure to go to it. We do not want you missing anything. We're waiting for the jury verdict in this case, and we're all guessing about what it might be. Now, before we go talking about MacGyver and before I get into the Grate case, which is another case we're covering today, I want to give you an update about something else we've been covering. As you know, a few weeks ago, we were covering the case of William Knight, a man out of Ohio who was charged in connection with the death of this young man, 24-year-old Keith Johnson. There was a dispute over a dirt bike. It went bad. He shot and killed this man. He claimed it was self-defense. Well, he was found guilty by a jury of his peers for murder and felonious assault. But now we have an update. That same man who was found guilty was just sentenced to life in prison and he'll be eligible for parole after 18 years. The William Knight case, ladies and gentlemen. As soon as there is an update in that one, we'll make sure to give you any information as it comes down the feed. We will always keep you updated about the cases we cover here on Law and Crime, and that's what we wanted to tell you right there. But now we should switch gears, because what we're covering today is also the Shawn Grate case. Now, this case, again, we've talked about earlier. It's another case out of Ohio, actually. This accused serial killer who's on trial for murdering 2 women, as well as kidnapping and raping a third. He faces a 23-count indictment, but we learned something interesting on Friday, that the trial is going to be bifurcated. In other words, the jurors will first hear arguments to determine whether Grate is guilty, and also they'll hear about the sexual motivation specifications. If they find him guilty of that, then the jury will be asked to consider the sexually violent predator specifications. And then if they find him guilty of that, then they'll have to decide what his sentence will be in a third phase of the trial. So let's try to understand why this is happening. Again, I want to bring in Randy Zelin. Randy, why would they bifurcate the trial like this? What's the motivation?
My sense of it is to protect a constitutional argument with regard to the constitutionality of the death penalty in Ohio. It's a very interesting thing that's going on here. Not too long ago, the Florida death penalty statute, as I understand it, was declared unconstitutional. Why? It all has to do with the jury and a defendant's Sixth Amendment right to have the jury determine the defendant's guilt. Apparently, under the Florida death penalty procedures, there was a certain aspect of it which the judge decided rather than the jury, and that would be an aggravating circumstance or an enhancement or something that takes the case out of your normal, okay, here's what you're going to get sentenced to, and now amps it up to a death penalty situation. And that was left to the judge rather than the jury. And it was determined to be unconstitutional. So I think what's happening here is the Ohio judge, the Ohio court, is bending over backwards to ensure that it is clear that the jury is deciding not simply guilt or lack of guilt, but determining that specific specification, which would and could ultimately lead to this becoming a death penalty case, and the jury deciding whether or not to recommend the death penalty. So by bifurcating the case, by splitting it up, saying, okay, first decide guilt. If you find him guilty, let's now move on to whether or not you find him guilty of a specific specification. If you find him guilty of that specific specification, now let's move on to the extent that it's now eligible for the death penalty. Now let's move on to the aggravating and the mitigation phase for you to determine whether or not you are going to recommend to me the death penalty.
Adding to that, this decision came after there was a motion filed by the defense requesting approval of up to $14,500 to hire a consultant from New Mexico to conduct an additional review of an MRI scan of the defendant. And the defense is really saying, and they want to bring in a specialist to talk about this.
John Fabian.
John Fabian, about the MRI results and trying to understand what's going on with Shawn Grate. And there's a lot of information that perhaps this man suffers from different disorders, and that might alleviate, that might kind of excuse his behavior, or maybe as a mitigating circumstance. Again, how should we think about that?
Okay, well, it's very interesting. Once upon a time, as I understand it, Mr. Grate entered a plea of not guilty by reason of insanity. There was a hearing held to determine his competency. There was a hearing held, and apparently, subsequent to that hearing, the insanity defense was withdrawn. So you've got interesting circumstance number one. Interesting circumstance number two, this case is mind-blowing, because since when in the history of the world has a criminal defendant been gagged from basically confessing that I committed the crime? And that's actually happened in this case. Mr. Grate has really bent over backwards to say, I did it. Now, that may be a demonstration of his insanity in terms of why he did it, but he has been telling everybody who will listen, I did this. But I think what's happening here is it was a fascinating move by the defense. Remember, if you don't ask for something, then it's not preserved for appeal.
Right.
So even though it was the last minute and they knew they could potentially get their heads handed to them, they went and said, Judge, time out. Let's not start the trial. We need money. And we need money because we want to hire John Fabian, because John Fabian is an expert who can come in and explain to the jury that this guy could not have, let's say, formed the criminal intent to do what he did, or doesn't understand what he did, because he's suffering from all of these defects. And Dr. Fabian can go well beyond simply an MRI conclusion, and he's an expert, and we're prepared to put him on, and we think it would be very helpful to the jury on the issue of intent and on the issue of the ability to understand the nature and consequences of Mr. Grate's action. What the judge said, because the prosecution went bananas, saying, how do you do this at the last minute? This is a complete sandbag. This is not cool. You should have done this in a timely fashion. And the judge said, you know what? Time out for a second. Here's what we're going to do. We're going to split the baby. This isn't an insanity defense, so we don't need Fabian, as far as I can tell, for the issue of guilt or lack of guilt. But I'll tell you what. I'm going to authorize the expenditures, let you guys do what you need to do, because it really is more for the death penalty phase, more for the sentencing phase, with or without the death penalty, if you want to establish mitigating circumstances that he was suffering from some mental disease or defect, which may not be enough to get him off by reason of insanity, but I should consider on sentencing, and I should consider, and the jury should consider, on whether or not to recommend the death penalty. I will let you do it, so the trial's not going to be delayed, but you can go do what you need to do.
It's interesting because Dr. John Fabian has talked about this new imaging that they might be able to do to see what's actually going on, and we should know that he's diagnosed Grate with persistent depressive disorder, unspecified bipolar and related disorders, generalized anxiety disorder, a language-based learning disorder, unspecified attention deficit hyperactivity disorder, cannabis use disorder, and other unspecified personality disorders with antisocial, schizotypical borderline traits. That's a mouthful. But at the end of the day, are those the kind of things that really could influence a decision in this case?
I mean, based upon those descriptions, it's not exactly moving me as I sit here, but certainly if Dr. Fabian is put on the stand and permitted to expand upon his findings and not talk at the jury, but explain it with them and really break it down into simple and easy to understand concepts, it may very well be that somebody sits there and says, you know what? I am not prepared to permanently punch this guy's lights out, or the judge may determine that, you know what, even if the jury recommends it, I found enough mitigation that I am not permanently dimming his lights.
It's pretty fascinating stuff when you break it down like that. Again, we are expecting opening statements today in the Grate case, and you'll get a good framework about what's happening here, both by the prosecution and the defense. So as soon as we have an update in the Grate case, we'll make sure to go to it. But as you know, we've also been carefully covering the Tex McIver case. It's a case that we've been following for weeks. How can we not talk about it right now? What I want to do is play you the testimony of Annie Anderson. Now, Annie Anderson is the masseuse that the prosecution put in, but really didn't put in, said that there was an affair that she was having with Tex McIver, but really not right. Again, you heard Clint Rucker say, I'm not saying that this is an affair, I'm just saying it doesn't look right. Well, the jurors are probably considering this, and again, I want to play for you the testimony of Annie Anderson, and then we'll talk a little bit more about it. Take a look. Welcome back, everybody. Okay, so we are shifting gears right now. That was the Claude Tex McIver case. We're going over now to Ohio. We have a live feed in the Shawn Grate case, this accused serial killer who faces a 23 counts in this indictment. Let's go live and hear what the judge has to say. All right, ladies and gentlemen, this is a live feed right now in the Shawn Grate case out of Ohio. It's about to begin. We're about to hear the opening statements. Again, I'm here with Randy Zelin. Randy, right before they begin, right before we hear the opening statements from both the prosecution and the defense, what do you expect?
Well, it's always difficult, again, to read tea leaves, but generally speaking, a prosecutor is going to get up there all full of fire and brimstone, even though an opening statement is simply supposed to be a guide to the jurors as to what the prosecution expects the evidence to show. But prosecutors, being prosecutors, tend to make it much more than that, and it will be interesting to see how much leeway the court allows the prosecutor. Nothing that the prosecutor says in an opening statement is evidence. And again, there is no evidence yet. It's simply giving the jurors a preview. So this way, when it comes to a point in the trial where evidence is being offered, the jury's like, yeah, I get that. I remember the prosecutor talking about it in his or her opening statement. A defense opening statement, don't be surprised if you see very little from the defense. The typical defense opening statement is usually little more than, ladies and gentlemen, you promised me during jury selection you would keep an open mind, you would follow the evidence, you wouldn't prejudge this case, you wouldn't judge this case based upon sympathy, you wouldn't judge this case upon anything other than whether or not the prosecution has presented sufficient evidence to prove my client's guilt beyond a reasonable doubt as to every count. And you keep it simple, you don't commit, you don't make a promise that you can't keep. You hope that the prosecution, as we've seen in other trials, perhaps makes a promise that the prosecutor can't keep. But from a defense standpoint, you want to keep your head down, you want to lay low, keep all of your options open, because it is not for the defense to do anything. The defense doesn't have to win. The defense doesn't have to prove anything. Sometimes, and in a case like this, all you want to do is come back to the jury and say, listen, they didn't prove their case. And there's nothing wrong with the defense being nothing more than it was their burden of proof and they didn't meet their burden of proof. So you want to be very careful not to say something that you will regret later on.
Randy, I don't know about you. That was a pretty good opening statement on both sides. Do we even need to watch this right now?
Absolutely.
I mean, but let's listen in live again. This is the Shawn Grate case out of Ohio. All right, so now the judge has provided those instructions to the jury. We see the defendant right there, Shawn Grate, facing 23 different charges. It's a lot at stake for this guy, and that's his defense team, and we're going to be eagerly anticipating the prosecution and the defense's opening statements, and as Randy Zelin said, it provides a roadmap of where both sides are going to go, although it's not really evidence. We have no evidence yet, but it's going to be interesting to follow nonetheless. One of the things that we believe will be called into evidence is that 911 phone call that we played for you earlier from, again, this woman, Jane Doe. That's not her real name. That's what she's been classified for. She is the person who was kidnapped and raped. Again, that's the allegations, one of the allegations facing this man. I want to play that 911 phone call because that's what led authorities ultimately to Mr. Grate. Let's play that for you right now.
911, what is the address to your emergency?
4th Street, Laundromat.
What's the problem?
I've been abducted.
Who abducted you?
Shawn Grate.
Where's she at now?
Asleep.
Where's she sleeping at?
In the bedroom. Please hurry.
Does he have a weapon?
He's got a taser.
Are you tied up now?
Yeah, but I kind of freed myself. Are they on the way?
Yeah, we have officers we're sending.
Please send them up.
Hey, if you're worried, you don't have to talk. You can just set the phone down, okay? I just need to hear if the officers find you or not.
Oh, shit. I woke him up.
Just set the phone down. Okay, can you get to the door where you can see out? Huh? Can you get out of the house?
Locked.
It's locked. Are you at the door?
Yeah, I am.
She's at the door.
Come on out. Hurry up. Get out of here. Where is he?
Bedroom sleeping.
Still sleeping?
Yeah.
Okay, they have her.
He's unarmed.
He's unarmed?
Yeah.
All right. Right now. Do it. Don't do that.
I I don't care how many times I listen to that, it always still gets me. It's so chilling to listen to. Now, again, that's a live feed into the Shawn Grate case, into the Shawn Grate courtroom, I should say, and that's the defendant right there. Again, I'm here with Randy Zelin. Randy, that 911 phone call, how will that be introduced by the prosecution, and more importantly, how will the defense try to argue against it?
Well, there's a few ways. Technically, that 911 call, it is an out-of-court statement, which is being ostensibly offered for the truth of what's said. So technically, it's hearsay. You can put her on the stand and have her talk about it and authenticate it and then put it in through her and then argue that it is sufficiently reliable because it's happening in the moment. Mm-hmm. It could be called a present sense impression. She's describing something as it's happening. Recent outcry I'm not so sure about, but look, that 911 tape is the least of Mr. Grate's problems. It's going to be very, very interesting how the defense approaches this case. We have seen, and don't be surprised if we see in this case, that they do not try to get an acquittal. That what all the defense tries to do in this case is save him from the death penalty.
Is it trying to humanize him if you're the defense? And again, he is innocent until proven guilty. So I want to make that very clear. I'm not saying anything yet until the court ultimately decides. But my question is it for defense, when you have these 23 counts, really serious allegations, you've seen him talk about in different media outlets talking about that he did this or that he's killed women in the past, is it trying to say, look, jury, he's a human being, let's try to understand what was going on in his mind? Is that the way to think about it?
Well, it's the difference between trying to humanize him, which I don't think you can. Even though sympathy is not supposed to play a role in our system of justice, it always blows my mind that we say to a juror, all I want you to do is come into the courtroom with your common sense and your life experiences. Yet, our entire criminal justice system is counterintuitive because in our everyday lives, we judge people. In our everyday lives, someone is guilty until they're proven innocent. If you lend your kid the car and your kid goes out and the next morning you come out to the car and there's a dent in it, and you say to your kid, what happened to the car? Imagine if your kid said, I don't have to tell you.
Yeah.
Is your kid guilty? Yet, in our system of justice, we presume everybody to be innocent. So I think it's not a matter of humanizing him.
Yeah.
That's pushing it. I think what it is, it's if I'm representing Mr. Grate, my game plan is I don't want him to get the death penalty. So from the moment the case starts, I simply want the jurors to be thinking that this is not appropriate to kill him, that he's got mental issues, he's got mental defects, he's not a monster by his own doing, he is not this animal that needs to be put down, that there are things that have happened to him that are through no fault of his own. This is what he was born with. This is how he was born, and you can't fault him for that. So punish him if you must, but don't kill him.
Is that also going to play into, again, remember, we know that Mr. Grate mailed letters to News 5 in Cleveland, Ohio, saying why he killed these women and explaining, and one of the reasons was government assistance was a reason, and the really bizarre revelations made in here about his religious observance and motive is obviously not an element of a crime, but it sure does tell a story. So when you try to understand these letters, again, is that played by the defense and say, look what our client is writing here? How does that play into it?
Believe it or not, where you would normally think that an admission is the end-all be-all for a defendant, and it is what the prosecution dreams of. In this case, if I'm representing the defendant, I am completely turning that on its head and using it to my advantage and arguing, ladies and gentlemen, no rational, no normal, I don't want to say sane because I don't believe that insanity is a defense here, but no sane person would say this person deserved to die because she was already gone the moment she started getting government assistance. She was already dead. So
what does that even mean?
I didn't kill her. She was already dead. So unless the prosecution is, again, like we just talked about in the MacGyver case, unless you want to say this guy was so diabolical, so twisted, so gone that he planned to do this just so his lawyers could come into court and say, see, No normal person would do that unless you believe that that was his motive. Those admissions could be the difference between him getting the death penalty and him being sentenced to life in prison.
And let me ask you this, small part, but I'm curious about it nonetheless. If that is the roadmap by which the defense will follow, does it also matter what he looks like in the courtroom? When we saw him, he's got not clean shaven. I don't even think he's wearing a jacket. He looks a little unkempt. If you're trying to say, look at our client here, ladies and gentlemen, is that important too? Important to see what the appearance is?
Everything that goes on in a trial is scrutinized. You would be amazed, or your viewers would be amazed, unless they have sat as a juror or unless they are practicing attorneys, what jurors pick up on. It is, when I'm on trial, it is a movie set.
Sure.
Everything happens for a reason. How my client is dressed, even from one day to the next. How my client is behaving sitting next to me. What my client is doing. Facial expressions at a particular time. Making notes at a particular time. Because you're always 1 second away from getting destroyed over something stupid. So absolutely, positively, you do not want this defendant walking in clean-shaven, hair combed, wearing an expensive suit. No, because it would be completely inconsistent with someone who is gone. No, you want him to look not like a complete disaster. You still have to have respect for the process and courtroom decorum. But no, you want the jurors looking at him and saying, even the way he looks, it makes sense.
Well, we'll have to see. Again, they're in a short break, and Randy's really making some strong points here about what we can expect for today, and that's really what we're trying to analyze. So as we wait for the Grate feed, as we wait for it to continue, we want to switch gears. Let's go back to MacGyver, because we are also waiting. We are in verdict watch in the Tex McIver case. We are waiting patiently to see what this jury will ultimately do. And again, I want to play for you some more testimony from this case, because every person that spoke was important. It was important for multiple reasons. One, even the witnesses that you thought were not important, the defense picked up on them and said, look at what the prosecution is doing. These red herrings. They're trying to make you think about things that don't even matter. And in the large scheme of this case, every word matters. So here's some more testimony from earlier in the Tex McIver case. Welcome back, ladies and gentlemen. So we're covering the MacGyver case. We're in verdict watch. I should let you know that the jury light is on in the MacGyver courtroom, which means the jury either has a question, they want to go on break, or they may have a verdict. So stay tuned. We'll keep you updated on that. Now we're going to go back to the Grate case in Ohio. We have a live feed, but before I do, I want to sign off today. My very special guest, Randy Zelin. Randy, thank you so much for coming on today.
Always a privilege.
All right, everybody, let's listen in live to the Shawn Grate case.